Counsel, be seated, please. One case on the docket today. Mr. Zients, I know you'll correct me. Up here we'd say Gauthier. I don't know if they say Gauthier. I'm not sure what you would say in Miami. But it's Gauthier or Gauthier versus Florida International University.
I was told Gauthier, but
That's fine.
it's fine. Good morning, and may it please the Court. My name is Mark Zients, Miami, Florida. I'm here representing Katia Gauthier, the appellant in this cause, from an order of the Judge of Compensation Claims below. May I please reserve 4 minutes for rebuttal time? Thank you. I'm well aware that the Court is well versed in these workers' compensation appeals and probably knows the facts, but very briefly, Ms. Gauthier was an 18-year-old college student working part-time at FIU as a recreation assistant when on September 13, 2005, in the course of her employment, was hit in the face by an errantly thrown football. She alleges that her glasses were broken in that incident, and by the next morning she had lost all vision in the eye and ultimately first went to Baptist Hospital and then on to the Bascom-Palmer Eye Institute, where she was operated on for a detached retina. She followed up with the Bascom-Palmer Institute, at first on a regular basis. She indicates that her doctors advised her to use a particular type of eye drop, not a prescription eye drop, but a particular type of eye drop that she purchased at a pharmacy. And she received, quite timely, the booklets from the Division of Risk Management, our state of Florida's TPA, and from Corvell, the managed care group, giving her an overview of her rights and her obligations. We've made that booklet part of the record, and if the Court wishes to look at it, it indicates various things that Corvell said they would do, including make sure she got her medical care, and she received forms to use to apply for her medical mileage, and she used those forms and applied for medical mileage to and from the hospital, but she never applied for medical mileage when she went out to get her eye drops. And the reason was that she had received a letter dated September 26th, also in the record, which told her, you may not be reimbursed for medical mileage to your pharmacy. Now, that was a total misstatement of the law, and the appellees have...
What about the eye drops themselves?
She was never told she could be reimbursed for those either, and never kept the receipts, of course never kept the mileage to and from the pharmacy, and by the time this matter came up, she was already moved out of Miami and up to Kissimmee, so there was no way to recreate those things, at least not without a great deal of effort. So she never asked for specific reimbursement for the eye drops or for the mileage. And of course our first contention, and probably the most significant contention, is that until the state tells her that she has the right to be reimbursed for prescription pharmacy mileage, that the statute of limitations is told. The judge didn't see it that way. He went into an estoppel situation and said that she didn't provide clear and convincing proof of estoppel. Of course, we disagree with that and that the judge has misinterpreted the evidence, because the only evidence is that she received a letter, she didn't apply for a medical mileage to her detriment, and ultimately the statute of limitations ran. You can't have a much clearer case than that, and certainly convincing. But this case points out quite a number of flaws in the way her compensation claim was handled. And I point that out because Judge Thomas, in your opinion, in the Overloop case, which talked about attendant care, you said it is well established that an employer carrier might not avoid payment by willful ignorance, and that the carrier has to monitor the need for benefits. Well, Katia Gauthier said she broke her glasses, and she told the adjuster and the nurse case manager, and she sent up the receipt that she got for prescription glasses in December of 2005, and they told her, you have to prove that you broke your glasses in that accident. Well, that's not the law either. The law is that they have to investigate the request for that benefit, do something to determine whether or not it's owed, and pay it if it is, or send out a notice of denial if it isn't. They didn't do any of those things. not a single phone call to any of her supervisors or coworkers or the HR staff at FIU to say, well, do you have any reason to believe she broke her glasses or didn't break her glasses? They did absolutely nothing except tell her, you have to prove it. Well, maybe that's what she has to do if she files a petition and goes before a judge of compensation claims, that she has the burden of proof. But at the self-executing end of the workers' compensation law, she doesn't have to prove it. It's up to the employer and carrier to investigate it. The next issue that came up was this issue of maximum medical improvement. And I would hope that this court would use this case as an opportunity to say the statute of limitations in a workers' comp case can't run until the employer and the carrier have established the date of maximum medical improvement. It's almost a given that when you're injured, when you've had surgery, when you've been out of work for a few weeks, that at some point in time your doctor should tell the insurance company, you've gotten as well as you're going to get. Well, this risk management never pursued maximum medical improvement.
Now, can you clarify a little bit of that? This Bascom Eye Center, according to the employer carrier, the university essentially, they never would establish an MMI. That's correct?
Well, they didn't respond to one telephone call.
Well, forget for a second, if you will, whether or not the EC was as conscientious as they should have been, but just they never established. I just want to get more into the factual details of the MMI. They never established it, right?
They never established it. And what we said in our brief is that at some point when you have medical records, which they did obtain, that shows that her vision is 200E or finger counting at 3 feet, that they didn't ask their medical director what did that mean. The adjuster said she had no idea, and the claimant had told them that she had lost the vision in her eye. Now, one would think that they would ask or do something. The obligation is to do something. In their own booklet, their obligation is to pay the permanent impairment benefits if there are any. What did they do? They could have set up an IME. They could have picked any doctor off their managed care list and sent her there and said, give us an MMI date. We can't get one from Bascom Palmer.
Whose burden is it to set up, to establish or to request an IME?
It's
situation?
Absolutely the employer carrier's burden. And they said so in their as a matter of fact, in the temporary disability section, where your temporary disability runs out at 104 weeks, the law specifically says 6 weeks before 104 weeks run out, the employer carrier shall establish MMI and permanent impairment. It's their obligation.
Is there a statutory duty here on the employer to set the MMI or the permanent impairment rating?
Well, I don't know whether it's specifically set out in the statute, but it certainly is set out in the paperwork that's sent to the claimant, and what she's told, and that is that we will do this for you. The nurse case manager said, I'm your nurse. I'm working for you. You're my client. But they did nothing. They had half a dozen nurse case managers on the case in the first 6 months, and none during the operative period of time from 07 to 08. So there was no advocate for this young lady. Nobody to go out there and say to the doctors, you must give us an MMI. You must fill out the DWC-25, which is in the appendix to our brief. And on the second page,
the employer carrier conceded that the provider, Bascom Eye Center, was apparently violating the administrative rules by not establishing the MMI, right?
Absolutely, but they continued to pay them. Why would you pay somebody that's not giving you the information?
Should the employer carrier have reported the provider to the Division of Insurance?
Absolutely. They should have done something with the absolute knowledge that this lady had lost vision in that eye, whether it's a 6% of the body or a 28% of the body rating, doesn't matter. And had she been paid that 6%, we pointed out, from the date that both IME doctors ultimately determined was MMI, this claim would have been timely. We also pointed out that the information given to the claimant about the statute of limitations was misleading. It says generally you have 2 years from the date of your accident to file a petition for benefits. Generally doesn't give anybody the absolute. The statute says you have 2 years. The letter says a failure to go to a doctor within 1 year may cause you to lose your benefits, not shall, but it is shall. And that's the way it was interpreted once she went more than a year without seeing a doctor. The bottom line here is that we're dealing with a system where people are not supposed to need lawyers. It's supposed to be self-executing. Employees are supposed to get the benefits to which they're entitled. And this young lady not only didn't get the benefits, but the employer carrier sat back. And whether intentionally or not, and I hope it's certainly not intentional, and I would pray that it's not intentional, got to the point where it was just a few weeks, more than a year, from her last doctor appointment. And as I said in the brief, we got you. Your case is closed. Doesn't matter we didn't pay you for your mileage or gave you wrong information and didn't correct it. Doesn't matter that we didn't pay you for your eyeglasses. Doesn't matter that we didn't determine your MMI and your permanent impairment. None of that matters. We got you. I'd ask you to reverse and remand for an award of benefits and really to set as a standard, at the very least, an employer carrier should have to establish a date of MMI before they can claim statutes run. Thank you. I'll reserve the rest of my 4 minutes and 2 seconds.
Good morning. May it please the Court? Attorney Shauna Andres on behalf of the employer carrier, FIU, and the State of Florida Division of Risk Management. The appellant has raised a lot of facts and in his brief mentions a lot of old case law and a lot of various bases for overturning the judges of compensation claims decision. But essentially, it's pretty straightforward. The claimant files a petition for benefits, and at that time, the employer carrier determines whether or not that is timely pursuant to the law. Once they raise the statute of limitations, then it becomes the claimant's burden to prove whether or not they, in fact, had notice.
Do you think this case could be properly analyzed by simply overlooking the fact, what appears to be more than an allegation, that this claimant was entitled to permanent impairment benefits going back to June of 2007? In other words, that wasn't one of your facts. Do you think that's an extraneous fact that you need not consider?
No, not at all. And my point being that it's clear that Judge Castillo did apply the appropriate legal standard in this case. And what I believe this Court should be looking at is whether or not there is competent substantial evidence to determine that the appellant...
That's not a CSE question, though, I don't think. The issue involving her entitlement to, the carrier's obligation to get notice of MMI and her entitlement to permanent impairment benefits. I don't see how that's a CSE issue.
Well, the reason I believe it's a CSE issue specifically is because in the case of Fontenelle's, there is no per se estoppel. Once the burden has met that the notice was sent with regard to what is required by the statute, then the claimant in this case had an affirmative duty to prove that there's clear and convincing evidence that...
Let me ask it another way. If she had gotten, let's ask it in a hypothetical. If she had gone to a lawyer, say, in December of 2007 and said, you know, it's been a few months, 6 months since I was at Bascom, and the injury's going back 2 years, am I entitled to any more money? Wouldn't the fact on the ground at that time have been that you're insured or you're self-insured, in fact, owed her several months of impairment benefits?
Okay, with regard to the impairment benefits...
Wouldn't the fact have been that you're insured at that time owed her several months of impairment benefits that had not been paid?
at that time, they did not owe her any impairment benefits, because the record actually
Because
shows...
there was no MMI? Right?
Because there was...
The snake
Speaking
has
with
swallowed
regard
its
to your
tail. That's
hypothetically...
answer. The snake has swallowed its tail. That's what I want to know. What's your answer on that?
My answer on that is simply this. The nurse case manager did exactly what she was supposed to do. She placed a phone call to them requesting the medical records. She also placed a phone call to them to please address MMI. She was advised that the report was not ready and they would send it to her, that they would address MMI. They did not do that.
And no one's accusing your client of bad conduct, but somebody was derelict and not established in the MMI. This provider was apparently violating the law by not providing the records and established in the MMI, right?
Yes.
Bascom violated Florida Administrative Code, right?
Absolutely. I agree that they did.
And so who's going to bear the consequences of that failure?
Well, the packet that she was provided specifically provides, after MMI, you will be entitled to permanent impairment ratings as given, and I can actually tell you exactly what it said. The packet that she was provided defined maximum medical improvement. It explained a claimant's entitlement to permanent impairment ratings. It states, these benefits are provided when the injury causes any physical, psychological, or functional loss, and the impairment exists after the date of MMI. As cited in their brief, it was so obvious even a child would know that she sustained this impairment. The packet also describes her right to go ahead and get an IME.
Excuse me, my question is, whose burden under the law is it, as a matter of law, to establish the MMI?
I believe it's her burden. If she had a question...
You think it's the claimant's burden to establish her impairment rating?
If the doctor was not establishing the... Answering your question simply, neither the claimant nor the adjuster can establish MMI. They can't. They're not medical providers. I believe the question you're really asking is, whose burden is it to obtain an IME to establish MMI? What I would assert to you is that they equally had the responsibility, the right to obtain an IME. And even in this case, because it was managed care, if the claimant had a question regarding permanent impairment rating, she could have requested an IME at the employer carrier's expense. She failed to do that. She did nothing. And because of that, the question is, was there a material misrepresentation with regard to her entitlement to permanent impairment ratings? There was no material misrepresentation with regard to her entitlement to permanent impairment ratings. The packet then goes into, if you do not agree, here's grievance procedures, here's the method to go to the judicial process, here's where you get the forms. You're entitled to an IME at our expense. All of this information was, in fact, provided to her, and yet she did nothing. And it's similar to what's interesting with regard to the claim for the medical mileage. She alleges that she was unaware that she was entitled to the medical mileage. Still no petition for medical mileage. Whether or not that was a material misrepresentation, did she rely on it to her detriment? And each of these situations and these failings by either party, there's no reliance on that to her detriment. And that is the reason when I was discussing what we're really looking at here is when the judge applied the elements of the estoppel, in each and every case, there may or may not have been a material misrepresentation. I don't think that that is what this is turning on. What this is turning on is, did she rely on it to her detriment? Are there things that she could have done, and is there competent substantial evidence in the record to support the judge's findings that, in fact, she did not rely on it to her detriment? Now, the one instance in any testimony at all goes to, yes, I would have had to get these specialty eye drops at a pharmacy. She didn't state what particular pharmacy she got them at. She stated a pharmacy like Walgreens. Interestingly enough, she never submitted for reimbursement of those prescription medications. She never submitted for any additional medical mileage whatsoever because she said, well, I didn't want to make copies or ran out of the form, and therefore I didn't make copies of the form. The reason she
What was the reason she gave for not submitting reimbursement for the drops themselves?
The evidence is completely devoid, and actually this is the first time that I've ever heard that she's claiming she had to pay for the drops herself. What is interesting is that nowhere in the payout ledger does it discuss payment for those drops, but at the same time there's never been a request.
Well, there may not be any evidence of that. I brought it up obviously on the appellant's argument because it struck me we're talking about mileage, yet apparently these were reimbursable medical for 4013 medicals, but there's no mention of it in the record. You're looking
yes.
pretty good on that because there's no mention.
Not only is there no mention of it, but these were not prescription eye drops. You know, are these the type of eye drops?
That wouldn't matter in terms of compensability, whether it's medically necessary, it would matter. Right.
Well, not only that, but is that something the doctor could have given her a sample of? And furthermore, after 2006, if you look through the medical records with regard to Bascom Palmer, there was never any mention that she was continuing to use these eye drops. The first time it gets mentioned is at the time of final hearing where she states self-servingly, yes, I'm still using the eye drops. But
back to the MMI question.
Okay.
If we were to write in this case, as appellant urges us to do, I assume then you would advocate that we write and say that that is a right that the claimant has, that and a responsibility that she shares with the employer carrier, and if she doesn't request an IME to establish an MMI, and a permanent impairment rating, then she loses. That would be the opinion we should write.
No, sir. My concern is more of a practical approach.
No, I mean as a principle of law. I mean, apparently the statute doesn't specifically define who has this duty. In other words, to make it clear when the one-year time clock begins. So we'd be interpreting the statute somewhat in paramateria, I take it, and trying to come up with a principle, unlike in the temporary disability section that your opposing counsel mentioned. Here, it's not crystal clear, is it?
No, and I think that may be appropriate for judicial legislation with regard to that. With regard to the MMI, can you imagine the slippery slope? And I practice, in addition to appeals, how many times you'll have claimants who just never follow up with medical care. They never follow up. They never continue. You have one right, the way the law is written now, to an IME. If the employer carrier has to go and use their one IME to obtain this information on behalf of the claimant, then they're losing any potential IME at a later date. If the claimant feels as though she's entitled to a benefit or had such a horrible injury that even a child would know, then it's certainly well within her rights. They gave her the grievance forms.
Well, I understand your argument on that, but if the doctors had provided the appropriate information in June of 2007, nobody would have had to spend their their IME during the next year. Isn't that? I mean, that's what I keep coming back to that. You've got. I like Mr. Zientz's phrase. I mean, it may not get him anywhere in the long run, but this is at the self-executing end of the spectrum of workers' comp. We get cases all the time involving things that come up at trial, and we hold the claimant's feet to the fire lines. But this is the self-executing end where the claimant, I think, arguably is pretty much entitled not to do a whole lot until she's notified that something has accrued, such as her entitlement to benefits.
The one thing that is being assumed here is that she would have been at MMI on June 21st, 2007. The subsequent IMEs did go back and ultimately apply that date. But standing in the shoes
Why
of...
should the carrier, and again, this is not a fault case. This is not somebody saying that the carrier is necessarily at fault, but there are certain procedures that need to be followed. Why should the carrier get the benefit of that argument, not having obtained the appropriate reports from the doctors in June of 2007? So we'll never know the answer to that.
I can tell you that that happens a lot. And
Yes, that's
here's...
Shouldn't we write, and shouldn't, excuse me for interrupting,
it's
Judge.
okay.
Shouldn't we write and establish a principle and say, employer carriers, if you have a recalcitrant provider who won't obey the law, you better take steps to get those medical records, report them to the state of Florida, get that date so that the system can execute properly. And I respect your argument about, hey, she had the right, she knew she was injured. But again, we come back to the fulcrum of this case, which is the Bascom provider just refused to follow the law and provide the data, correct? You said so in your brief.
Well, let me...
I mean, you implied that in your brief.
I think we're talking about two separate things here, okay? And if you'll just hear me out for 1 second, I think I can make it clear. June 21st, 2007, there was a request to address MMI, and there was also a request to address and to obtain the report. They did not address MMI. In addition, they didn't provide the report. The medical bill comes. If the adjuster doesn't pay the medical bill, then you're also not providing benefits to the claimant in the sense that if you don't pay the bill, they won't see the claimant again.
And I don't think I suggested you not pay the bill. I suggested that when the medical provider does not provide the form to establish the MMI in a self-executing system, whose responsibility is it to make sure that the Florida Administrative Code is followed and that form is provided?
I can tell you exactly whose responsibility is. I see my time is pretty much up, but let me answer your question, please. Under the Administrative Code, you can elect not to pay a bill until you receive that medical report, okay? That is the only recourse that you have, is that you continue not to pay the bill. However, if you do not pay that bill, they will bill the claimant, even though they're not supposed to, which creates the same exact situation where the claimant is having to go out and obtain an attorney, go through the grievance procedure, and do all of these things.
But, if I may, Judge, but wouldn't that actually trigger the event that would put everybody on notice there's a problem here? In other words, it's interesting you have that leverage. If your carrier exercises that leverage and tells Bascom, which, according to your brief, as I read your brief, it's a problem with Bascom. You had a problem with them, and as I recall from the brief, it's not isolated. So if your carrier tells Bascom, we are not paying you until we get that form. Now, you bill the claimant, perhaps that tells the claimant, I better go see a lawyer because I'm not supposed to pay this bill. And then everybody's put on notice, we have a problem.
The slippery slope that would occur if that were to happen could potentially provide that the statute of limitations never runs in that sort of situation. And just in closing, there was no material misrepresentation, but even more so, she didn't file the petition, and that's not the basis of her petition. There's no evidence in the record that she relied on that, and that was the basis for her not filing the petition. It's distinguishable from Roberson, where she was given misinformation. She had the information to obtain an IME. If it was so obvious even a child would know that she would be entitled to benefits, she had the right to execute and obtain her IME as well. And I think it's an equal right between the employer carrier and also the claimant. Thank you.
Appellees started out by saying that I've relied on old case law. I think they call that stare decisis. And I'm happy to rely upon old case law.
What do you say to her argument about it's your client's right to ask for the IME, and practically speaking, if we rule in your favor, there won't be a statute of limitations?
When does she ask for the IME? Does she ask for it after the first doctor visit, the second, third? How does she know she's reached MMI? She doesn't know those things. She doesn't know to say to the doctor on each visit, have I reached MMI? When does she ask for this IME? Is it premature? She uses her one IME and then that's it? This case points out that the carriers have asked for something and they've gotten it from the legislature, and that's total control over medical. If she wanted an IME, it had to be from their managed care list. Otherwise, she had to pay for it herself. The doctors who are authorized, she can't pick her own doctor. She has to go by who the carrier sends it to. In this case, they sent her to Bascom Palmer. And they sent her there knowing that Bascom Palmer didn't comply with the rules. And now they want to step back and say, well, it's not our fault.
What about your opposing counsel's argument that that wasn't the basis of your estoppel claim, essentially?
I don't think there is an estoppel issue here. It wasn't brought up at trial, and it wasn't brought up in my appellant's brief, initial brief. But counsel said here again today that we gave proper notice. And they said in their brief at page 23, the petition is untimely, and the carriers demonstrated notice to the employee pursuant to 185, that's the booklet, and the employer posted notice as required by 440.055. Well, actually, it's 440.40. There's a misstatement in the statute. But if you want to present an affirmative defense of statute of limitations, you have to prove each element of the affirmative defense. And they tell you in their brief, one of the elements is posting notice. There's no evidence that they ever posted notice. There's no evidence in this record anywhere that that broken arm poster was anywhere to be found for these FIU employees. They haven't satisfied the most basic element of requiring the claimant to overcome a stop, to present clear and convincing evidence. They don't have an estoppel argument. We do. They don't. Claimant relied to her detriment. You have her mileage forms. And here's the booklet. It says you will be reimbursed for prescription drugs. This was a non-prescription drug. They didn't tell her she could get reimbursed for non-prescription drugs. This whole claims handling process is faulty.
Your time is gone, but what's troubling me a little bit about your main argument is there are issues of credibility there. You may have all, in the light of this favorable view, you may have the best evidence on that, but there are issues of credibility. And what I'm struggling with here is why couldn't the JCC have simply said, I'm not going to get to the question whether she's misled, because I don't think she ever did any of this. I don't think she went to the drugstore.
Didn't find that. Her credibility in the judge's order is not challenged. He doesn't say I don't believe her. And she testified in her deposition, and she testified at trial, and she continued to go to get these non-prescription drops because her eyes teared and they were painful and they got dry. And she explained the use of the specific drugs that the doctors told her you should be getting these. Now, I think the real problem here is the shuffling under the rug of the eyeglasses, the failure to do anything of any consequence to get their authorized doctors to tell them about MMI, and the failure to provide the benefits that they said in their booklet would be provided. So I appreciate your time.
If I may, Judge, if we were to write an opinion and only address the MMI issue in this case, what would you recommend we say?
If you noted in the brief, or in the record, there was a question asked as to whether or not the adjuster ever filed a DWC-4. That's the form that tells the state, we've started compensation, we've stopped, we have an MMI, we've started permanent impairment, et cetera. Well, risk management doesn't file those. They're as guilty as Bascom Palmer. And you've got to handle these claims in the appropriate manner in order to come back later on and say, statute of limitations is run. You can't not do your job and be able to rely upon
So
the
under
statute.
your view, the statute hasn't even begun to run
It's
today?
told. When the case came out that clarified medical mileage to prescriptions, they didn't send another letter out to this lady and say, oh, by the way, the court's clarified the prescription thing, and our letter to you was wrong, and now you should apply for it. That's what they should have done. I dare say the letter probably says the same thing today it said in 2005. I can't prove it, but thank you very much.
Thank you both for your advocacy.